Good afternoon and welcome to today's edition of Democracy and the Rule of Law, a program where we'll take a look at topical national issues from the perspective of the rule of law and the Constitution. My name is Judith Urenwa. On today's edition of Democracy and the Rule of Law, we'll be taking a look at the Supreme Court judgment which sacked Emeka Ihedioha of the PDP as Imo State Governor and declared Hope Uzodinma of the All Progressives Congress APC winner of that election. And also the update on Operation Amotekun. If you recall, last edition of this program we took a look at Operation Amotekun and the various challenges facing the particular operation. The federal government at that time was silent, but now the federal government, through the Attorney General of the Federation, has declared the operation illegal. But this is not coming without some controversy and also reactions from stakeholders. But first, we're taking a look at the Supreme Court verdict on the Imo State governorship election. Let's quickly take a look at the reactions of counsels to both parties on Tuesday, and we'll be right back. Just stay with us.
We want to return all glory and honor to the God Almighty, that we are vindicated at the end of the day. Our position from beginning to this end has been that the case of Imo is very unique. It's different from all election petitions in Nigeria. Because whereas others were complaining about non-holding of election of the various units, Imo's election petition was about exclusion of votes. We want to say that the God of Imo State has spoken. Yes. This evening, distinguished Senator Hope Uzodinma has finally been declared the elected governor of Imo State. Yes. This is a story that has been in the community in Imo State that Hope Uzodinma won the election.
You're welcome back. Now, this is the background to what led to that comment from those two gentlemen. The Supreme Court on Tuesday nullified the election of Emeka Ihedioha of the People's Democratic Party (PDP) as governor of Imo State. The Apex Court declared Hope Uzodinma of the All Progressives Congress as the winner of the March 9 governorship election in the state. In the unanimous judgment of the 7-member panel read by Justice Kudirat Kekereekun, the Apex Court agreed that results in 388 polling units were unlawfully excluded during the collation of the final governorship election result in the state. Justice Kekereekun said that the result from the 388 polling units added Mr. Uzodinma polled a majority of the lawful vote and ought to have been declared the winner of the election by the Independent National Electoral Commission (INEC). The judge did not provide the details of the new votes scored by each of the candidates after the addition of the result from the 388 polling units. Consequently, she voided and set aside the declaration of Ihedioha as the winner of the 2019 governorship election in the Southeast state. The court ordered that the certificate of return wrongfully and unlawfully issued to Ihedioha be immediately withdrawn by the INEC and a fresh one issued to Senator Hope Uzodinma, which INEC has since done on Wednesday. Well, let me quickly introduce our legal practitioners who will be taking a look at this particular issue. It's nice to have you, Barrister Shakira Molaja. You're welcome and Happy New Year.
Happy New Year, my sister. Thank you for having me.
All right, Barrister Michael Munnan, it's nice to have you.
Thank you very much. Happy New Year to everyone.
Thank you, and Barrister Femi Aino, you're welcome.
Yes, thank you for having me.
All right, INEC had declared Ihedioha, a former Deputy Speaker of the House of Representatives, winner of the governorship election in Imo, that is March 9, 2019. INEC said Ihedioha, the former governor, polled 273,404 votes ahead of his closest rival and candidate of the Action Alliance, that is Uche Nwosu, who the electoral body said scored 190,364 votes. Also is the son-in-law of former Governor Rochas Okorocha, who strongly backed his candidacy. By the INEC result, the candidate of the All Progressives Grand Alliance, ABGA, Ifeanyi Ararume, came third ahead of Hope Uzodinma of the All Progressives Congress, APC. The former polled 114,676, while the later, that is Hope Uzodinma, polled 96,458. A total of 70 candidates representing various political parties participated in that particular election on the 9th of March 2019. And now, Supreme Court verdict. Bryce Afemi Imo, yes. What's your take on this?
Well, it's quite disturbing. Disturbing in the sense that you've had a governor in place for almost 10 months or 7 months, and then suddenly we have a decision of the Supreme Court. You see, let's forget the mathematics, how they arrive at their decision. Let's look at the after effects and what's the message. This sent a powerful message that, number one, you can't rig yourself to power. I'm not saying whether this man rigged himself or whatever. And number two, those who want to contest as a governor come 2023, some of them will have a rethink. But my major concern, of which I'm concerned about, I'm not the Supreme Court, that's the last court in the land. They've taken a decision, we have to respect that. And I don't want to second guess the judgment by saying maybe their calculation should have gone this way, or how come somebody who scored, who was the third person in the election managed to now become the winner, whatever. Let's just leave that, because otherwise we will be reopening the case. But my major concern is that, is this the way to go in this country? We had an election in February 2019. Come February, I know we're in January now, by February 2020, we are still talking about election. The United Kingdom had an election in November 2019, just a few months back, and Boris Johnson is now the Prime Minister. There is no case in court whatsoever up till now. Even the leader of the Labour Party has to resign because everybody has come to terms. And you see, the disturbing aspect is that, what is the point of having this electoral law and what have you? What is the point of having INEC? And left to me alone, once the court rule against INEC or any of the candidates, if I'm the chairman of INEC, what I will do is to go back to the drawing board and read the judgment, digest it, debate it, so that we can avoid what is called a future occurrence. And my concern is that as we speak, I think next week or so, they are still about we don't even know. And also, there are still some rerun election and senatorial going on in various parts of the state. Now, if care is not taken, some of these disputes about 2019 election, we even drag up to 2023 if we are not careful. So, you know, my major concern is that the way it's supposed to be. So, definitely, I don't know what will be my brother's opinion.
Okay.
It shows that something is wrong somewhere. Either we are not getting it right, either we need to go back to the drawing board and start again. I will give way to my brothers.
All right, while you give way, many questions have been going on from people who are reacted. They're wondering how someone who came a far third, he was fourth actually. Fourth, yeah. How someone who came fourth eventually, you know, became winner of the election, and how the Supreme Court validated his results, which INEC, the Electoral Tribunal, and the Appeal Court found invalid. How do you How does it settle with you?
Judy, as my colleague Aina has said, it's worrisome. It's actually worrisome because some of us who have actually have knowledge of how this thing works, the law concerning electoral cases. You know, election petition is in a class of its own. It's what we call sui generis. It has its own class completely, different from every other case. Now, in an election petition, you are expected, a petitioner is expected to call evidence, witnesses from the polling booths, polling units. You understand? The presiding officers, those people that actually recorded the vote, the result. The petitioner is expected, if you are complaining of exclusion, you are expected to call those people to come and tender the document, the vote, and then be questioned, because anybody who is presenting a document and evidence in court that cannot be questioned, the evidence cannot be relied upon heavily. You understand? What we call probative value will not be attached to the evidence. But if you bring somebody that does not have the capacity to answer questions regarding the document that you have presented, you are actually making a guesswork. And so what we have seen here is a situation that the petitioner, so to say, that is Uzodinma, had actually called somebody that is a policeman who was not at the polling booth, and to witness the election, to come and tender these documents, the 366 documents that were tendered as exhibit, covering 388 polling units that were purportedly excluded. This man had no capacity to answer the questions, and even in the most recent case delivered by the Supreme Court itself, in the case of Atiku and Buhari, the court said that it is not proper. You cannot, nobody can rely on an evidence that is not brought, that is not tendered by the polling unit agent, those who made the document. So in this case, the polling unit agents were not called. So what happened that in this particular case, what we call dumping, that is carrying documents that were not prepared by a particular person in a box to come and dump on the tribunal, is now allowed to become evidence. It is an issue that it's a development in the legal lexicon that we are thinking probably is going to change the fundamentals of election petition in the subsequent years, unless there is something that is going to happen and the Supreme Court will overrule itself subsequently. Otherwise, we are going to see a situation that even the old cases will have to be exhumed, and somebody will now start thinking how this could happen and that the Supreme Court should overrule itself based on this particular decision. So it is worrisome in the sense that my colleague has said, over almost 1 year now, after this man has started as a governor, and there is an overturn. He's no longer the governor. Another person, a new governor, has been brought in, and then he has started his own regime that is going to also cover another 4 years. You understand? Trying to set aside all the things that this man had done and all that, the probe and all manner of the intrigues that are involved. You see, I'm saying this because we are talking about law in politics, democracy and the rule of law. You understand?
Yeah.
Otherwise, if I were to be a politician, I would align myself with the particular political bias that I have. But I don't, because I'm talking about law. The Supreme Court is the highest court of the land. And we are, as lawyers, are not expected to criticize the decision that is made by the Supreme Court. You can only voice out, as we are saying now, that it beats our imagination, my own imagination, to see how the Supreme Court lets or arrive at this decision. And the only challenge we are now having at this point in time is that we have not read the full judgment to know exactly what we are reading are the snippets from here and there picked together. I also read the dissenting judgment of Honorable Justice Oro of the Court of Appeal, who in this particular case, because he was the only one that dissented. When I went through it, I could not also agree with the holding of that Honorable Justice, because he was actually holding that those documents were admissible in evidence. You understand? And that based on that, he was able to add those votes to. And when you look at it, you discover that the APC or Uzodinma party did not have a single member in the House of Assembly. When you take a lot of things into consideration, you now feel there's something wrong somewhere that would have foisted, so to say, a governor on the people when the people did not actually say you should be our governor.
All right then.
Those documents, I'm going to come. Okay. So those documents that were actually admitted by the Supreme Court, to my mind, are suspect.
All right then, Barrister Shakira Molajo, how do you see all this?
The lesson for me here is never say never. It's a good thing my learned friends have cautioned themselves, like every good lawyer must caution himself, remembering that the Supreme Court is the final court on anything litigated upon in this country. After the Supreme Court, you take your appeal back to the Lord Almighty and to the electorate. Having said that, like they said, like the immediate past speaker said, we have not read the full judgment. We have reasonings being proffered. And the summary of the reasoning given by the Supreme Court that we all, I am assuming, have read is that elections are decided on the basis of lawful majority votes. Emphasis on lawful and majority. Here was a gentleman, Hope Uzodinma, who said, look, my lawful votes have been unlawfully discountenanced. My lawful votes have been unlawfully disallowed. If you allowed my lawful votes from 388 polling units, I should be the winner of this election. He lost at the tribunal, he lost at the Court of Appeal. Lo and behold, he got to the Supreme Court and he won. So we say to ourselves as legal practitioners, when we are faced with such scenarios, you represent a client, you lose at the High Court, your client looks at you, lawyer, what next? We say, we still have hope.
Yes.
We go to the Court of Appeal, you lose. Your client looks at you and says, lawyer, what are we going to do? And such victories are usually very, very sweet. Taking into cognizance the English proverb, he who laughs last, last best.
Indeed.
Hope Uzodinma today is the governor of Imo State. Again, I say, we should not forget that the panel was unanimous. A panel of 7 exceptional youths. To be at the Supreme Court, you are exceptional. No matter what anybody wants to say. You are the peak of your career. 7 of them, no dissenting judgment. And just like Lord Denning, of blessed memory in England, who was oftentimes in the minority when he was in the Court of Appeal giving judgments. Because Lord Denning was a man who was ruled by his conscience. He saw a lot of injustices in the way matters were being decided. Then he will rule, he will, according to his conscience. Then it so happened that those minority judgments that Lord Denning found himself giving in some matters, the Parliament in England legislated upon them and made them the law of England. What am I saying? There was a soul of the Court of Appeal who had the singular courage to say, gentlemen, I do not see it the way you have seen it. I'm sure that man must be smiling in the corner of his house now or the corner of his office that I told you something was not right with the decision of my learned friend. But again, the majority at the Court of Appeal had their say. Justice So had his ways. Today, everybody is made quiet. The final court of the land, the Supreme Court has said, again I must emphasize, unanimously, a panel of 7 persons have said, indeed, an injustice has taken place here. If we are going to be fair by understanding that here is our reasoning, lawful votes were ousted, bring in those votes, and then number 4 shall now become number 1. And it is for this reason that I say, never give hope. Whatever you find yourself do, and it's the time, look at the name of the 10th man, just like the former president of the country, Goodluck Jonathan. And I say, if this is not irrelevant, I say to our parents, to our women, to Africans, pay attention to what names you give to your children.
All right, very
We have Goodluck Jonathan. We have Goodluck Jonathan. Now, have you even asked yourself the meaning of Uzodinma? Hope, we all understand.
We get there.
Uzodinma means the good road, the good path. So a man of hope on the good path has found himself against all expectations, being declared governor. Number 4 is now number 1. Do you not see divine hand? I'm not talking about
well, let's hope he's the hope the people of Imo State are hoping for.
Yes.
Hope. All right, now let's look at while you've already set the tempo, we can't question the Supreme Court. Former governor of the state, Emeka Hildia, on that same day, he made a live broadcast and he said he was deeply shocked by that particular verdict. But who is it to question at the Supreme Court? He has accepted his fate, but he is still in shock. Let's look at INEC. I've read a lot of comment on this particular verdict, which somehow people were saying it cast aspersion on INEC and the 2019 elections itself. If 388 polling units were excluded from, so what is the fate of others who did not get the appeals that just stay put at the Court of Appeal that didn't go over to the Supreme Court? So what does it say about INEC as an electoral umpire to you, Barrister Femi?
Thank you. Well, it speaks for him. I think I've addressed that earlier. That is INEC, you see, with this Uzodinma decision, coupled with others, it's a testimony that it's either INEC is not fit for purpose or they need to be strengthened somehow.
In what way?
Well, it could be in terms of human capacity, and it could be in terms of legal capacity as well. Because it's not supposed to be this way. Something is wrong somewhere. Why is it that in this country, once we had an election, people just don't take it in good faith? This is the result. And for that to happen, they need to believe in that process or processes. That yes, it's transparent, they are not unlawfully excluded. We are talking about Uzodinma now. It's just because he has the war chest and he has the nerves. What of, assuming this man doesn't have money, let's forget the weighty allegation against him. Assuming the man doesn't have the money to go up to the Supreme Court and they stop at that Court of Appeal, what's going to happen? He will be putting up with one form of injustice or the other. And that is my concern. And the way forward now is either there should be a root and branch reform of INEC, or in the alternative, they need to send these people for some form of capacity training somewhere. Why is this happening? It's still disturbing. And even if we have to use proxy vote, whatever vote, people need to have confidence in that system. And if they have confidence in the system, whatever result you declare, they will not go to court. And my major concern, please, all of us are going to put up with this in the long run. For now, we don't have a case at the Supreme Court. it's okay. We can sit here and talk about it. But if that court gets overwhelmed by election petition, if you have problem because of your family land with someone, the Supreme Court will not sit on that case for years. Yes. And you'll be going to that court day in, day out. There are women who are seeking fund one way or the other from their ex-husband, and the case is in all these courts, but the court can't sit on them because politicians are just overwhelming that court with petitions day and night. It can't continue that way. And if we don't address it now, all of us are going to suffer that injustice. And the injustice is happening because some of these cases will go to Court of Appeal. The Court of Appeal will be dealing with election matters for months. People who has already been sacked one way or the other unlawfully, they have matters at the Court of Appeal. You understand? They can't hear those cases. And I must say to you this, that even in some of those courts, the condition in which these judges are working even make it difficult for them to sit for hours because they have one medical problems or the other. I know that because to even get 3 of them to sit at the Court of Appeal is a big problem sometimes because of one medical problem or what have you. And now we have issues where what they are dealing with since February last year up till now is election petition, up to presidential election, governorship election, senatorial election. What is going on here? Do we now have another? There are 2 ways to it. And what they don't do here, of which I'm even alarmed, is this. And I will tell you, you see, sometimes we need to try and get the Court of Appeal to be able to come up with a very watertight judgment. And what we can do is this, and this has happened before. They do it in England. If you have a case at the Court of Appeal, and they look at the counsel who are coming there, some of them, they are just, they've been there for years, even before you are called to the bench. They can bring a judge right from the Supreme Court just to sit as a judge of the Court of Appeal on that day in order to strengthen the capacity of that court, taking account of the issues, because they don't want the issues to move forward to the Supreme Court and what have you.
Right.
Now we can borrow a leaf from that. And my major concern about this case, thank God for Hope in Uzodinma. He has the money, he has got the power, but are we progressing or retrogressing? That is the fundamental question. There is the need for policy consistency. Now you have a governor who has been there for 7 or 8 months. It's been going on a certain direction. Now we have this court judgment. Why don't we make sure these matters are concluded within 4 weeks? Otherwise, you know, it can cause all sort of a policy somersault. And that is what the people of Imo State are going to put up with if care is not taken.
All right, Mr. Munan, what's the implication of all this?
About this INEC issue. I want to believe that INEC is actually operating under the law that sets it up, and then the law regulating the elections. You understand that the moment there is violence in any polling units, INEC is empowered not to allow the election. You know, they carry the ballot box, carry the election materials, and disappear. Go to somewhere and sit down and write those things. So INEC can decide, because of the violence in that election polling unit, there was no election there, and they cancel it. That is what the law has empowered INEC to do. And that was exactly what INEC did in respect of this, because INEC actually disclaimed those results because they had actually cancelled election in those polling units. So if that was done, you cannot now turn around to say INEC should be held responsible because the elections that they had actually disowned, or the votes they had actually disowned and disclaimed have now been accepted. You understand? Because they are working under the law that establishes and the law that regulates the election itself. You understand? So the only thing is that whenever, like my colleague said, whenever there is this kind of a situation, I think it's supposed to sit down, overhaul itself, look through the documents and situation and see how they can adjust in the next coming election. This one is gone already. There is nothing you can do about it. Okay. The next one, you look at it and see how you can manage situations. If it is still going to happen that people will still go and snatch ballot box, carry ensure that policemen are stationed are briefed properly, because there are always policemen even in front of the polling unit, and this staff will go carry the thing, and the police will allow them to go. Even the ones that are armed outside will see them and allow them to go. So what they should do is to ensure that they don't allow this violence to be perpetrated by some people, because at the end of the day, the people that perpetrate the violence are the same people that will come to cry foul at the end of the day. So I feel that INEC should sit down, look at the situation, and see how they can talk to the IG, talk to the security personnel or outfits that are involved in election days, and then tell them, on no account must you allow violence. No matter what happens, if somebody tries to do something, make sure you take the person out of the scene and allow the election to go on, because we are not going to allow ballot boxes to disappear, ballot papers to be snatched and all that. These are the crux of the matters.
All right, with what you said, many stakeholders are of the view that we should do away with security agents during election.
No.
What you're trying to say is that we have not come of age to that point where we'll do without security agents during elections in Nigeria.
You can't do without the security agents there, because if the security agents are there and people are still going to snatch the ballot boxes and ballot papers, what if they were not there? So people would, because some of these thugs are armed, well armed, and they can kill their opponents and do a lot of disaster there.
All right, Barrister Molaja, what's your take?
My take is simply this. You should not forget that INEC is made up of human beings, Nigerians. You should not forget that rightly some INEC officers were indicted of having collected bribe, of having compromised their position as unbiased polling agent officers. If we bear all this in mind, then we know that the first thing that INEC should do is to do in-house cleansing. How do you do the in-house cleansing? How do you recruit your personnel? Do you recruit them on the basis of political affiliation, recommendation, or do you have a screening that passes through our security agencies like the SSS and whatever? Do you recruit like we know they do, youth corpers who perhaps were court members in their schools, who perhaps are able to be the agents to tell those who are going to snatch the boxes what time to come, when to strike and such things. We remember the story, very, very sad story of how a bank was robbed recently, and it turned out that a banker in the bank was the one who actually invited the armed robbers. So the recruiting process must be cleansed. Having said that, there's something this country is missing, sorely so. Where is technology in all that we do? What does it cost us to have each polling unit wired with cameras? Everything does not have to be with violence and gun. Let me tell you, please, and I share this with Nigerians. The average Nigerian is afraid of being caught on camera. Because when people have a saying, there's no cheating in what the camera has resulted. It is the way you present yourself that the camera will reproduce you. What we realize in this age of photoshopping, technology, fakes and such things. But talking ordinarily, where is the place of technology? Audio recording, video recording. The average policeman does not want you taking a camera to his face to record his name, to record what he's doing. I learned just before I came here today that even some police officers, to collect bribe, they are going around now with POS. But you will not be able to really say that and prove it if you don't have it on camera. If you have a polling agent, that was the case of Lawan, the former legislator, and Otedola, made easier for the public to understand and maybe pass their comments. At the point, Otedola came up with voice recording of Lawan, and that man became dead practically since then. If I said, it is technology, and the man said, I have more. So I am encouraging this country called Nigeria to please, it is, look, talk is cheap. Anybody can talk and condemn. The average man who is given a national assignment does not want to fail for the sake of his name and posterity. But how are you assisting them? Remember, rigging in this country has gone sophisticated. What happened in some states, I don't want to mention names now, is that they ensure that the opposition could not even successfully organize a primary election. In a situation where you are unable to organize a primary election to field any candidate.
All right.
I said I'm going to mention names. What happened is what happened in River State.
All right.
What happened? So we know, but with technology,
all right,
and with Nigerians not being too ambitious,
all right,
then we can get it right.
All right, Emeka Ihedioha is the first of the governors elected during the 2019 elections to be removed by the Supreme Court. We have other appeals still pending, and we'll wait as issues turn out. I'll be right back on democracy and the rule of law to discuss them.